I can talk to you a little bit about my thoughts about the Second Amendment because it's in chat. Why not? We can talk a little bit about how I think about the Second Amendment. Not my first time talking about it. Some people in chat disagree with my reading, but I'll give you my reading for whatever it's worth. So, the Second Amendment to the Constitution says a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Okay. Now, a lot of people focus on the words shall not be infringed. It's like, well, it says shall not be infringed, so that means shall not be infringed. What's there to debate? And I'm like, well, the thing that you guys might be missing is what shall not be infringed, right? To say shall not be infringed doesn't help you unless you say what shall not be infringed, right? What is the thing that shall not be infringed? And it says, well, my right to own guns. It's like, no, it's not what the Constitution says. We have to read it more carefully. We have to read it like a lawyer, right? What shall not be infringed? The right to keep and bear arms. Okay. So now we have to have a discussion about what is the right to keep and bear arms. Now, the word the, as an article, it means it's referring to a specific antecedent. It's a specific antecedent. That's what the word the is. It's referring to a specific thing, not a general thing. So if I say I want a apple, any apple will do. If I say I want the apple, I'm referring to a specific apple and not other apples. So if you give me a different apple, it's not the apple I wanted, no matter how similar it might be. I want that particular apple, the apple and no other, right? So what we have to really decide, in my view, is not what shall not be infringed means, although we can have a discussion about that too. What we really have to decide is what the means. What is the right to keep and bear arms? And understand that, now we have to suddenly go into common law, right? It's very much the same. It's very much the same as in the First Amendment, because the First Amendment talks about the freedom of speech, the freedom of religion, the freedom of press, right? So freedom of speech doesn't mean all speech. It refers to the freedom of speech, not all speech. What is the freedom of speech? Well, as I'm sure many of you guys know, it doesn't include such things as libel, defamation, slander, true threats, fighting words, and examples like that, right? Because those things were never thought to be part of the freedom. The freedom of speech does not include those things. Those things are excluded from the freedom of speech. They are not part of the freedom of speech because they're never understood to be part of that right. So they're not within the scope. So that's an example. So then for when it comes to the Second Amendment, we have to do a very similar historical analysis. We have to go through the English common law as it was developed and the American law as it existed up till 1789 when the Second Amendment was adopted, right? So we have to understand what the scope of the right is. So it doesn't necessarily include the right to have any arm you want or bear it in any manner you want, in any place you want, at any time you want. Shall not be infringed does not mean that your right to have guns. It does not mean your right to have all guns of all kinds, in all manners of bearing, in all places, at all times, right? It is not that. Whatever it is not that. So just because they're restricting or even potentially banning something does not mean the right has been infringed, because we first have to have a much more intelligent discussion about what the right is and what the exact contours of the right are, with all of its nuances and its meanings and its understandings. And so that's the part where I think a lot of the Second Amendment people trip up, is trying to understand exactly what the scope of this right was in those kinds of things. So that's sort of where I think you need to go. And in much the same way, as I said, when it comes to the First Amendment, like what do we mean by freedom of speech? What do we mean by the freedom of speech? We have to go through the English common law. What do we mean by the freedom of religion? Well, we have to go to the English common law. What do we mean by the freedom of assembly? Well, let's go to the English common law. What is the existing right that we are adopting? What are the scopes? What are the contours? What are the limitations? What are the boundaries of this thing that were understood as what things were in, what things were out? What were the boundaries of this thing that was designed? It's like the piece of land. What is the piece of land? What are its boundaries? What are its features? What are its places where it has inlets? And what's a place where it has, parts that bulge out? It's probably not just a perfect square. It has parts that parts that leap out and parts that leap in, and it has this more nuanced, crazy line, maybe potentially, like the piece of land. What are its boundaries, right? So we have to, if we're doing that for a piece of land, we have to break out the surveyor, man. We have to break out the surveyor and figure out exactly what the boundaries are, and it might be all kinds of weird shapes. But the land has boundaries, no matter how weirdly shaped it is. It's not your right to the land is not the right to land, period. It's the right to the land as it exists, with all of its shapes and contours and exceptions, and incidentally, anything that might be riding along with the land. For example, easements that might be riding along with the land, or covenants that riding along with the land. This analogy is becoming increasingly irrelevant because some of these things don't exist in the Second Amendment circle. But it's just to show you that when you're talking about like the land, you have to have a much more nuanced discussion of exactly what we're talking about. When you're talking about the freedom of speech, you have to have a much more nuanced discussion of exactly what we're talking about. So for me, that's where things meet the road on the Second Amendment, is not in shall not be infringed, but rather instead what the right is and whatever its contours, its boundaries, its limitations. What does it include? What does it exclude? And how is the right understood? And, for that, you can go read any number of amicus briefs that were filed in Heller and McDonald, and for that matter, NYSRPA. One of the nice things about these cases of Heller, McDonald, and NYSRPA is that they have oodles and oodles of amicus briefs, and many of which are going into deep dive historical analysis, trying to describe what the Second Amendment includes and what it excludes from a variety of historical perspectives. So I think that's the part where people in the pro-Second Amendment sphere kind of lose the plot, is that they kind of think it necessarily means the right to have all guns for all purposes at all times, in all places, all locations, in all manners. And whatever it means, it certainly does not mean that any more than it means that when it comes to freedom of speech. So that's kind of how I think about it. In terms of what I think the dominant, although not necessarily exclusive, meaning of the Second Amendment is, what it seems to me, and it seems to me also that this is further validated by the Militia Act, is right. If you think about the Militia Act of 1789 or 1793 or whatever it was, right, defines all the militia as all the men between 17 and 45 who are supposed to bring firearms from home in order to be part of the militia, right? The firearms they brought, they had to bring themselves. It wasn't to be provided. And so it seems what the Militia Act is contemplating is that people are going to bring the firearms that they have, that they use on a somewhat regular everyday basis, right? So when the Second Amendment talks about a well-regulated militia being necessary to a secure state, well, what's the well-regulated militia? What does the militia look like? The Militia Act of 1793, at least it partially informs this, because it's 17 to 45-year-olds who will be bringing the firearms they have from home, the firearms that they're presumably familiar with, for hunting or self-defense or otherwise, the firearms that they might have an occasion to use on somewhat of a regular basis, so they would have familiarity with it. So it seems like the right to keep and bear arms are those arms specifically that are most likely to be used and kept for what you might consider ordinary domestic purposes. So firearms that would be used typically for hunting or typically for self-defense or typically things of that nature. So it seems to presumably contemplate pistols, shotguns, and rifles as the primary firearms, because presumably those would be the ones that people would be bringing into service because they would be the ones that they'd be most familiar with on a somewhat regular basis. The whole idea seems to be that as the church bell is ringing, people are bringing firearms they're already familiar with, so they don't have to be particularly trained or specially trained, that they're already competent in some loose sense with their use, so they can be pressed into immediate service. So the Second Amendment, particularly by reference to the militia aspect of the Second Amendment, appears to be contemplating those firearms that would be in ordinary, normal domestic use for ordinary, normal domestic purposes, and the extensions thereof. So it would be modern versions of modern pistols, modern shotguns, modern rifles seems to be the scope and contemplation of the Second Amendment, particularly with respect to the militia clause. The well-organized militia not only indicates a purpose of the Second Amendment, it also seems to indicate firearms that are suitable for that purpose, which also is a holding, incidentally, from United States versus Miller, which is a trash opinion, but nevertheless is an opinion of the Supreme Court that has to be given some due weight. So that's sort of what I think is contemplated. So I somewhat and I also think that the Second Amendment, when it talks about the right to keep and bear, is talking about an individual use. It's talking about one person. Again, if you think about it from the militia purpose, which is also baked into the Second Amendment and further validated by a Militia Act, you're talking about an individual, what an individual can use. You're not talking about anything an individual can't use. So you're talking about what an individual would have an ability to use on a somewhat regular basis, so they would be somewhat familiar with it on occasion that have the ability to use it. So again, you're thinking pistols, rifles, and shotguns. So for example, at least from my mind, talking about an atomic bomb is ridiculous. It's not an arm within the meaning of the Second Amendment. I know you can think of it as an arm within the meaning of, for example, an arm reduction treaty. So you can think of it an arm in that sense, but I don't think it's an arm within the sense of the Second Amendment. I don't think the Second Amendment contemplates that, because that wouldn't be something that would be within an ordinary, common, normal use of an ordinary, normal, common person for ordinary, common, normal purposes even today, let alone at the time. So talking about an atomic bomb is completely ridiculous. Or talking about a fighter plane, or talking about a tank. I mean, those are completely ridiculous. Even if they could be used by one person, they can't be maintained. They can't be really faithfully operated. So I think it's completely ridiculous. So I think, all those things, those examples, I think are not within the scope and the meaning of the arms. Again, they might be within the scope of arms for some other statute. They might be within the scope of some other treaty, because every time the word arms is used in some other law, it might have some other meaning, as that law might contemplate within its own terms. But whatever arms means within the scope of some other law does not necessarily implicate the Second Amendment. So I think that, while, nuclear weapons are obviously considered arms for the purposes of an arms reduction treaty, they are not arms within the meaning of the Second Amendment. Because again, the right to keep and bear arms, the right is understood as it existed at the time, and we have to understand its fundamental purpose, which is informed by the Militia Clause, which extends to individual people using individual weapons for individual purposes with some individual familiarity. So therefore, pistol, rifles, and shotguns and their modern brethren are contemplated, and not, for example, tanks and atomic bombs. So that is my view of the Second Amendment based on my understanding of the historical analysis and what is going on. So that is sort of I tried to read up on this. I think I read every brief in Heller and McDonald. I haven't read any of the briefs in NYSRPA, but that is my view of the historical analysis. So, and I think what the Second Amendment is attempting to contemplate. So, and then also, of course, we have to have a side discussion about what does it mean to infringe that right, which is a whole other discussion. So what does it mean to infringe that right exactly? And that's a whole nother discussion that we can have. So for example, is it necessarily infringing? And I'm not taking a position on this either way at the moment. I'm just asking the question for the sake of asking the question. So, but is it necessarily infringing to have, for example, a background check? Is that an infringement or not? And you could have a discussion about whether that qualifies as an infringement. And you could have a scope about what exactly does it mean to infringe the right? Is that an infringement or not? So you could have discussions around that when it comes to regulations too, but that's a whole nother set of problems. So that's sort of my short, off-the-cuff Second Amendment analysis. Yeah, just wait until I tell Nick on you. Nick knows. Nick knows. This is not a surprise. Nick and I have a divergence of opinion. I can't speak to how well-informed his opinion is in terms of reading the briefs and things like that. So maybe his opinion as well as informed mine. But that's my considered legal opinion for whatever it's worth. So I think, respectfully disagree with Nick. And if one of you guys goes into Nick chat and be like, well, Uncivil Law called you out, I'm going to be a little grumpy. Because I'm not calling him out. I just respectfully disagree with him. I've done my due diligence. I've done my research. And this is my considered legal opinion at this moment about what it means. It's I love people like this, man. I love people like this. Kimberly says, talk to Tiebeard, you're wrong about the history. Look, Kimberly, I don't know how to tell you this, okay? But I've done my due diligence. I've done my analysis. That doesn't mean I know all the things. But I read every single brief in Heller and McDonald. When in law school, I wrote for my third constitutional, which was completely optional. I wrote a paper on the right to keep and bear arms. I wrote a complete history of it for the analysis. So I think my view is fairly well informed. But other people can read the history differently. It's okay. There's a whole scope of people who have written amicus briefs, on this issue at the Supreme Court, and they don't agree with each other. That's just my considered opinion.